Today we'll be discussing on a topic understanding the non-compliance and violation difference under the environment law in Indian context. Generally, it is understood that non-compliance and violations are same, or rather used interchangeably. But in terms of the environmental aspect, there has been a very clear differentiation between non-compliance and violation. So we will refer to a circular office memorandum issued by Minister of Environment Forest dated 29th June 2010. In this circular, or rather office memorandum, the method of monitoring of units which has been given EC has been said. So in this circular, the ministry said the regional officers have been entrusted with the responsibility of monitoring the compliance status stipulated under the environment clearance to various development projects under the EIA and the CRZ notification. Now, what happens during the the monitoring exercise that has been done? So it further says actually like that during such visits. So when the regional officers of the Ministry of Environment Forest makes a visit, that they may observe non-compliances or violation. And it very clearly says, the circular dated, office memorandum dated 29 June 2010 very clearly states that based on the gravity of the situation, the regional office is required to report the same within 30 days of such visit to the IA division, the Impact Assessment Division, for further action, including legal proceedings under the environment law. So basically what happens is that when there is a visit, there may be a situation where it can be a non-compliance case or a violation case. Now, what is the basic difference between non-compliance and violation? So let us take the meaning of non-compliance. Non-compliance, what has been said, that failure to meet the regulatory requirements set out under the environmental law, permits or condition, either partially or fully, but without necessarily causing direct environment harm. So the very important point here is, in the case of the non-compliance, there should not be any environmental harm. Examples of that has been stated as like non-submission of environment audit reports on time, then failing to install pollution monitoring equipment as mandated, operating without valid environment clearance, though no damage may yet be proven. Of course, this aspect we will be discussing on the Supreme Court judgment which has recently been passed, where it's on 16th May 2025. So the precondition is that there should not be any environmental harm. So in that situation, it can be considered as a non-compliance case. Now, in the case of a non-compliance, the ministry has said that okay, you have to report this non-compliance to the regional officers, to the Impact Assessment Division. Now, the second aspect is violation. Violation has been said that is a breach of law or a specific legal provision, especially where there is an actual or potential environmental damage or harm. So as we have seen, in the case of the non-compliance, there is no environmental harm. It's only a procedural aspect or administrative aspect of non-filing. But in case of the violation, it's actual or potential damage to the environment. So it's a violation is a very serious aspect. Now, examples of that has been given. This example is like discharging untreated effluent into water bodies, then illegal felling of trees or encroachment into forest land, operating industrial activity in a prohibited zone. There are many instances. So ministry has very clearly said that in this office memorandum that violation means cases where projects have either started the construction work or installation or excavation which is earlier on site, or have expanded the production capacity and or project area beyond the limit specified in the environmental clearance without obtaining prior EC or change of scope without prior approval from ministry. So even starting a work without proper environmental clearance amounts to violation. Now, violation is a very, very serious, uh, you know, serious problem to the project proponent. So, Ministry has actually opened up windows for post facto EC approval, which was particularly reference to the OA 77 2021, and has done post facto EC approval. Now, what is post facto EC approval? That okay, the project has started, then the project proponent comes, and then based on the assessment, the EC is granted. Now, in the recent case, the Supreme Court case on judgment on 16th May 2020-25, the Hon'ble Supreme Court in the case of Vanshakti versus Union of India has issued a very clear verdict by striking down the office memorandum of 2017-21 issued by Ministry of Environment Forest, where the procedure for post facto EC approval has been mentioned. The steps that is to be taken, the penalty that is to be levied, everything was being mentioned in that circular. However, the Hon'ble Supreme Court judgment very clearly says that this circular is illegal, thereby under no circumstances ex post facto environment clearance can be issued by the central government, whereas the already issued EC under this particular provision between 2017-21 remains unaffected. So basically what the Hon'ble Supreme Court has said that there cannot be any such situation where the project proponent starts the project, starts work, starts excavation, starts whatever the activity that has been mentioned here as in terms of definition of violation, like either started the construction work or installation or excavation. So anything that is there, so whether anything that you do without the environmental clearance is a very serious violation, and the serious violation has to be dealt. Now the Hon'ble Supreme Court also emphasized that under Article 21 of the Constitution of India, the right to live in a pollution-free environment is guaranteed, and noted that Article 51 AG makes it the duty of every citizen of India to protect and improve the natural environment. The court observed that even the central government has a duty to protect and improve the natural environment. So basically, the Honorable Apex Court judgment is very clear that there will be no leniency as far as environment is concerned, no development to compromise with the environmental law. And this circular, by striking down the circular, the Apex Court has very clearly given the priority of proper procedure. Observe the Apex Court has made certain observation about these type of projects, and so it's very important. It is very important the project proponents have to ensure that they obtain the proper EC. Even the cases where the renewal of the CTU, the consent to operate, comes, there needs to be a very tight scrutiny on the EC, whether the EC is there in place or other thing. So with this judgment, it is now very clear that environmental violations will not be taken lightly by the even developmental boards, the pollution control boards in the state, and the ministry will further have to clarify, make this system more transparent, involving various stakeholders, and non-compliance matters may also result to violation. For example, somebody has not filed their half-filled return. It may seem to be non-compliant case, but when there is an inspection or when there is a deeper verification of the non-compliance, it may come to the observation of the regulatory authority is that there is a serious violations, which may be irreversible environmental damage. So it's important that all the stakeholders understand this judgment, and ensure that there is a compliance at the initial level, so that there will not be any such instances of violations which may affect many. the livelihood of the locals, the environment, and overall, it has a lot of impact on many aspects. I have made a small article, written a small article, the link of which will be shared in the description below, wherein I have made a small comparison between the non-compliance and violation matters, and reference to the Hon'ble Supreme Court judgment. So I request you to make a detailed study on this and spread this information to project proponents, to people, not to break the environmental law, which is not only today, but it will be affecting all of us, all our future generation. And with that, I conclude, and thank you very much.